In today's video, I want to go over a common question, and that is, how much time do I have to do on an aggravated charge in Louisiana? Well, this is a good question, and first of all, you should know that the term aggravated charge is really just something that is used in prison lingo. In Louisiana, the technical term is what's called a crime of violence. And if you are convicted of a crime of violence, that will determine realistically how much time you would have to serve in jail in terms of your good time release date, as well as any potential parole release date, okay? So what is a crime of violence? In general, crime of violence is any type of crime that it requires the use of force upon a person or a piece of property. Now, the law does give a list of specific cases that do and do not constitute a crime of violence. But in that same statute, there's also what's called a catch-all provision that allows the court or allows the Department of Correction at some point to say, hey, look, this particular act, even though it's not listed as one of the enumerated offenses, would constitute a crime of violence. So if you are convicted of a crime of violence, how much time are you going to serve? Now, this question does assume that you are actually going to jail. There's been some recent developments in the law in 2017, and in order to control the prison population from completely exploding, they gave out more good time and parole eligibility time to people who are convicted of crimes moving forward. So as it stands today, if you are convicted of a first offense crime of violence, you would be eligible for parole after serving 65% of your sentence. What does that mean? That means that you are in jail, you will get an opportunity to go in front of the parole board after you serve 65% of your sentence, so on 10 years, that's 6.5 years. And you will be able to show the parole board what you've done in jail. How many write-ups have you gotten? What type of organizations are you involved with? What type of rehabilitation programs have you taken? Have you undergone furthering your education? What opportunities are available for you on the outside? And of course, because it is a crime of violence, they will also get the victim of the crime to give a statement if they so desire, and the district attorney and the sheriff's office can be heard as well. But assuming you are released on parole, then it's almost like you're going to be on probation. They're going to let you out of jail. You're going to have certain conditions where you have to you're going to have to reside in certain places without getting permission to move. Now, what happens if you don't get parole? Well, most crimes have good time eligibility, okay? And so what is good time? Good time is really like an accelerated sentence. After you serve so many days in jail, they credit you with serving additional time. Right now, for crimes of violence, a good time rate is 75%. So basically what that means is for every 3 days in jail, it's like you serve 4, okay? And so that knocks off the time that you are released. In a typical case, once you have reached your good time limit, you're just flat out released from jail. But the Department of Corrections does have the power to, and you will see it on crimes of violence, to release you on good time as if on parole, meaning you have a supervisor to report to, and if you mess back up, you can go back to jail and serve the remaining 25% of your sentence. Now, there are some exceptions to both parole eligibility and good time eligibility for crimes of violence. First of all, you have to look at the charge. Some charges prohibit parole. Second-degree murder, first-degree murder. There's no good time, there's no parole for all of those crimes. Armed robbery and first-degree robbery. Those are robberies either with a gun or the person believes you have a gun. And for those offenses, you are not eligible for parole. So you may be eligible for good time, but you're not eligible for parole. You're going to have to look at to see if the statute deprives you of the benefits of probation. Now, if it does, if it deprives you of the benefit of probation and parole, you still may be good time eligible. Now, there is another type of exception that we're going to look at, and that is people that are adjudicated as a habitual offender. This is called a multi-bill. If you're adjudicated as a habitual offender, then you are not eligible for good time. So on those cases, your only chance is potential parole. Now, if you are convicted as a habitual offender of a crime that has no parole eligibility, well, then you're going to do each and every day of that sentence. In Louisiana, there are 4 different ways that you can post bond. What a bond is, it's a surrendering of some type of property or assurance that would allow someone to be released from jail and go to court while their case is pending. The easiest way to make a bond is by posting a cash bond. Someone is arrested, the judge looks at the seriousness of the charge, looks at their criminal history, and then says, I'm going to set a bond in the amount of $10,000. Well, if the person or someone on their behalf wants to pay that, they can take $10,000, go deposit it with the sheriff, and then the person will be released. So long as the person comes to court, when the case is over, regardless of the outcome of the case, the person or his family will get the $10,000 back. Now, if they do not appear in court, then they will forfeit the $10,000. The second type of way to get someone out of jail is with a property bond. And so this is where someone pledges home or land as collateral for the bond. Now, the property has to be located in Louisiana because the court has to have jurisdiction over the land. And you can stack up multiple pieces of property to satisfy the bond, but this is how it works. You look at what you pay in property taxes, you look at your assessed value. You take from that assessed value, you subtract any liens. Generally, it's a mortgage or a second mortgage. And then that difference is what is available to post a bond. Again, you can stack up multiple pieces of property if you need to. It only costs a couple of $100 to file a lien in the court record and a couple $100 to remove it. So it's pretty cheap, and as long as you think the person is going to show up for court, you really don't have anything to worry about. The third type, and it's probably the most desired, is a sign-out bond. This is a release on your own recognizance or release from a personal surety, someone who says, I will make sure they go to court. This is basically the honor system. And as long as the person goes to court, no one really has to pay any money other than like a $30 or $40 processing fee with the sheriff's office. But if someone doesn't show up to court, then whoever is the surety, whether it's the defendant himself or his mom or his dad or his wife, will then be personally obligated for the entire bail amount, and then can have liens placed on their property, wages garnished, what have you. That is not reserved for every type of bond. It's generally for nonviolent crimes or misdemeanors and generally reserved for first offenders. Now, the most common bond is the commercial bond. That is where you go and actually pay a bail bondsman to post a bond for you. What you do, the state law of Louisiana says you have to pay 12% to a commercial bail bondsman. They can't charge 14%, they can't charge 10%. It's 12%. 2% goes to the bail bondsman. The other 10% goes to execute an insurance contract with the sheriff that posts your bond. As long as you appear in court, you don't owe any other money. If you do not appear, then the court can move against the bail bond company's insurance underwriters for the full bond amount, and you have signed over documents that allow the bail bonds company to go after you to indemnify them for the loss in its entirety. Now, the downside is that when the case is over, you don't get any of your money back. But it is the most common way to get people out of jail because people do get arrested for serious crimes or are repeat offenders, and they tend not to have property or cash to satisfy large bond amounts. So the bail bondsman can work. Those are the 4 ways to post bond in Louisiana. Bail bondsmen work 24/7. Property bonds are done during normal court hours. Personal recognizance or cash bond can be done any time of the day.